But why isn't the causal relationship, the chain, broken in the sense that you have voluntary decision-making by Texas, say in relation to the criminal justice costs, that you feel compelled or you want to go after individual people? In other words, aren't the costs associated with Texas's decision to incarcerate or parole certain non-citizens if the federal government decides not to detain them, aren't those a result of the state's own policy choices in a way, that we have recognized or decided is not sufficient in a case like Pennsylvania versus New Jersey?
Your Honor, I think ordinarily in the court's Article 3 standing analysis, for example, in the DACA case in Regents, the court didn't go, well, California is suffering this injury in the first place because they have chosen to employ individuals subject to this immigration right, et cetera. And so really, to some extent, the loss of these individuals is a self-inflicted injury. More to the point, Texas suffers injuries regardless of what it does, whether it detains, releases, or paroles individuals, because we have not only law enforcement costs, but social services costs and very serious threats of recidivism.
Well, all right, well, separate out can we just for a second separate out the criminal justice costs from the health care and other things that would be required? With respect to the criminal justice costs, presumably, first of all, the federal government has said that they've determined that these particular individuals aren't going to be a high risk, and so that's why they're not detaining them. So why isn't Texas's determination to detain them on Texas? I mean, presumably there'll be other states that might agree with the federal government and say, we're not going to expend any money to try to supervise or detain these particular individuals.
Well, 2 points, Your Honor. First of all, there are district court findings. In fact, this was a disputed subject at the trial court regarding whether or not the rates of recidivism were acceptably high, what kinds of risk Texas was exposed to by these releases. And more to the point, Congress has made the determination, specifically in the passage of IIRA and 1226C, whether or not these individuals are unacceptably high.
Well, that's on the merits. That's a merits question. I mean, I guess my point is just in terms of injury and who is bearing the cost and why. Isn't it Texas's determination to go after and detain or keep detained these people, a cost that Texas has chosen to incur? The guidelines don't require states to keep these people in custody.
No, Your Honor, and I think that's because Texas is put to what we might call sort of an Article 3 dilemma, where it either pays the costs of continued detention or pays the costs that are incurred through recidivism. Again, recidivism in this case being a hotly contested question at trial, upon which there were direct testimony from one of the largest counties in Texas regarding the criminal population there, actual evidence of recidivism by specific individuals who had been detained and released pursuant to detainers.
All right, so can we answer Justice Sotomayor's question about net cost then? So fine, there might be costs with respect to this group of people, but the federal government says that you're going to save a whole lot based on other aspects of the operation of the guidelines. What's your response to that?
Two responses to that question. The first is somewhat straightforward, which is to say that's in the nature of a factual assertion about which the petitioners offered zero evidence whatsoever. That was a disputed fact question at trial. They offered no evidence. If there were in fact evidence, I think that would be powerful evidence attacking our standing. Their assertions afterwards